when you're writing a will, now you have a will, and you're estranged from your family, even your immediate family, you still have to provide for them.
Okay, so here's the thing. You have an obligation to provide for that family. Unless you state why you should not provide for them. And one of the things that people state is that those people had enough means of their own, or that you had already provided for them during their lifetime. So we tell people who do not wish to provide in the wills for the first category of people, please state in your will why. And some people will say, I do not wish to provide, say, for my wife because she has enough property of her own, or because I had transferred this and this to her. I do not wish to provide it for my son, and it is intentional because I've already given him enough property. You see, you could give reasons. Yes, exactly. Yeah.
What is the costly trauma? Is that a reason?
It is a reason, because if you look at the categories of so if you leave out a beneficiary, if you leave out a child, if you leave out a spouse, they can come to court and apply to be provided for on the basis that they have not been provided for. Now, one of the things they have to show is their means, their future means, but also the relationship between you, the person that died, and themselves. You see? So it does matter. But you see, if you're not here, we're only listening to one side of the story. So it is good, if you do not wish to provide for someone, to put it in writing why.
So someone has died without a plan, a will. So how is, to whom is the property divided?
Very
Are
good
there
question.
categories there?
So the law provides that an intestate estate, as in where you do not leave a will or estate plan, can only go to certain categories of persons. Those are your spouse or spouses in the case of a male person, your children, whether or not maintained by you at the point of your death. And children does not refer to just those who are under 18. It refers to those who are born of you or adopted by you. The second category includes your siblings, your parents, your step-parents, and children you've taken into your family as your own, provided that you are providing for them at the time of your death. So a very dear friend of yours cannot come in and seek a share of the estate because the categories are closed, so to speak. But when you plan, when you have a will, there is no limit to whom you can leave your estate to, provided you also leave to those two categories that I have told you about.
So it is a must that you leave to the first two categories.
Indeed. Even in a will, there is a responsibility to provide for your dependents. Your dependents, according to the law of succession, are those ones that we mentioned in category 1 and category 2. Category 2 is subject to them having been dependent upon you immediately before you died. Category 1 is entitled, that's the children and your spouse are entitled whether or not you are maintaining them at the point of your departure. That's the difference.
Very interesting. Because I mean, I think if you were estranged from the second category, say I have never spoken to my parents for the longest, or siblings, and I would want to will a friend something, then I think I would have the right to do that. Wouldn't I? that point?
When you write.
Yes, when you write the will,
Yeah.
you have what we call testamentary freedom. The freedom to will as you please. Gift your friends. Gift an institution. Okay? But when you don't do that, then you're straight-jacketed by the law.
I see. Okay.
You see? That's the difference.
But within a will, you have to first provide for the spouses and children.
Within a will, you must make reasonable provision for them.
Okay.
Then over and above that, you can deal with your estate
Okay.
as you would wish to.
Reasonably.
A reasonable provision. Yes.
I read somewhere that people who do fraud, so they actively check out their obituaries, and then they call the family, claiming to be creditors, like the person who died, owed them money, and it's fraud. And that article was making a case for why it is important to plan your estate. Yeah. So is that possible? Can someone actually benefit like that through fraud?
Well, they can, because creditors also have an opportunity to object to the distribution or to claim for their money from the estate. You see, creditors do. So now, if we don't know who your creditors are, and they perhaps forge documents, they could succeed in a court of law. So why don't you state that I owe these debts or I do not owe any debts? It makes it easier for everybody. And I'm sure I would be looking at that cross in the wheel and showing that person claiming, look here, on the court. This person said that they had no debts. Yes, exactly. So it is important.
Judy, it sounds like dying without a plan is time consuming. It costs a lot. So what's the cost, really?
The cost is even difficult to quantify. Start from the fact that this person that has passed away may be the secretive type. So you have no idea where to start in getting their documents. Okay? So you ask friends, neighbors, circles, dig into their suitcases to try and get and piece together what they owned as an estate.
And probably they had a separate house somewhere.
And then, exactly. And then you're thinking, how do we even know whether this person had any money in an account? It's circles, did they have any savings and what have you? That is very difficult for a family that's grieving. They've just lost a loved one. Okay, that's firstly. Then you piece together all those pieces of papers, and you now start the process of going to court. And that process is not cheap. For a lawyer to do it for you, the fees would be about 1 to 1.5% of the value of the estate. Okay? You can self-represent. Of course you can. But it's a daunting, process for somebody who is not a lawyer. But people do it, and it's encouraged, because the court also try and help people. But it's a process that you would wish you would not have to be involved in when you are emotionally involved in a matter. And it's also possible that because you don't have legal advice, you could even end up missing certain steps. And so you go to the end and then you have to come back to the beginning. And then you could even leave out beneficiaries, because please note, it's also an emotive process, and you're the one doing it for yourself. So it's expensive emotionally, it's expensive physically, and it's also expensive financially. A will is quite straightforward. You see, if somebody has left a will, even though it has to be taken through the process of legalization or probate, as we call it, you see, it's quite straightforward. Everything is here, is on a piece of paper. I think it is possible to argue that it will be financially less expensive, it will be emotionally less expensive, and physically less expensive. Yeah. When a person dies without a will or without estate planning, there is a void, there's a vacuum, because there's nobody who's legally empowered or entitled to move the affairs ahead. Okay? And you can actually be prosecuted for involving yourself in the affairs of a person that's gone because you don't have the legal authority to do so. Okay? And this person that's called an administrator, they only get power to administer or deal with the estate at the point of getting the grant from the court, as opposed to a situation where you've left a will. The powers of the executor, the persons you have named, they establish from the point of your death. And whatever acts they carry out, provided they are in accordance with the will, okay, are going to be validated when the grant is issued. Do you see the difference? Yes, so your will is read and it says the executor should do this, should do this. There is no vacuum.
Correct.
They will do what they can in the interim. You leave no will, there is a complete vacuum up to the point that the grant is given by the court.
So is there ever a battle as to whom the administrator should be in the interstate succession process?
Maybe it's easier to ask, is there never a battle? Are there cases? There are endless battles about who the administrators should be. In many cases, people misunderstand the responsibility, the power of an administrator. Because that administrator will have to administer that estate in accordance with court orders and based on the consent of beneficiaries. But many people think that the fact that you become an administrator gives you advantage over the estate. It actually doesn't. It's actually work. Because eventually, who gets that glass, who gets that money in that account and what have you, is totally dependent upon the confirmed grant. And which confirmed grant the beneficiaries have had to say yes to. Do you get me?
Yes.
But the battles are constant between polygamous households, among children and their parents, even when there is no polygamous household, and among many other people.
So who can be an administrator?
So the law provides the several categories of persons that can do that. Surviving spouse or spouses have the first priority. And then beneficiaries entitled on intestacy. Remember, we spoke about the beneficiaries. We talked about the spouse. We talked about the children, and then we talked about those other people, siblings, parents, grandparents, all those. Remember those people we talked for. So those ones are also in the third category in terms of priority. The public trustee. There's an office of a public trustee who takes charge of estates where on behalf of people. Okay, that's an office, of course, in government. And then creditors, so that even a creditor can apply to be an administrator because they owed money. Nobody's applying to administer the estate, so they can apply to administer the estate so that their debt can be paid. Yeah.
I mean, it seems like a lot of work to be an administrator. Moving from one office to another.
Yeah.
So as a creditor, it would have to at least measure up to the amount of work I'll put in, if I understand that correctly, right?
Absolutely. The only reason you would do it as a creditor is because you owed money.
Yes.
So I guess it has to make economic sense.
And so for the public trustee, that's a paid service by the government, and I'm assuming that would be paid through whatever this comes out of succession?
Absolutely. So the government takes over the estate and administers it on your behalf. And of course, there's some money paid, from the estate, yes, for the work done.
Okay.
Yeah, or for the service given.
Interesting.
Yeah.
Sometimes, by the way, our government surprises me because of how many services we have that most people are not aware of. That's something. Yeah.
Absolutely.
It's amazing.
Yeah.
From all these discussions on estate planning, I think for me, two key points that I take away with me is that one, estate planning is not just for the wealthy, and that estate means whatever property you have. It doesn't have to be tracts of land or houses or what. It can be things that I value, and then I get to determine who succeeds them after I am gone?
My takeaway is how important it is to plan your succession. I mean, it sounds like an interstate succession process is very cumbersome. There's a lot involved, and if we can write our wills, I think that'll be very ideal. It simplifies the process, and as you had said earlier, it takes away that vacuum of who will be doing what, who takes what. It just takes away a lot of convolution into the whole process of succession.
We must do this. We must do better. Because, many of us, we're hustling so hard. We're working so hard. And if you, and by the way, eating so little of that which we earn. And if you ask us why, it's because we want to leave something for our children. But we do the exact opposite when we do not leave wills, when we don't plan how that will be succeeded to or will be inherited by our children. We're doing the exact opposite. So let us be intentional. Let us do something. The moment is here. By the way, Ken and Carol, we should also remind our viewers that we would be very happy to know if there are any topic that they'd like us to discuss in Family Matters, and also whether there are any questions that they have. We'll be more than happy to respond to them. Thank you.
Absolutely.